Good afternoon, everyone, and welcome to this week's afternoon program. The South African Bar Association hosts a speaker on a weekly basis to deal with a legal topic intended to assist young practitioners with training and development, and in so doing, to improve the quality of legal practitioners in our courts. This is a core value for us. It is an honor and privilege to host Advocate Chris Georgiades, SC, of whom most of us are familiar with. Advocate Georgiades shall be addressing us on a topic titled "ENQUIRES in terms of Section 417 of the Companies Act." A few housekeeping matters. These sessions are recorded, and we appeal to participants to ensure that your microphones are muted and your video cameras are switched off. Accordingly, during the address, all participants shall automatically be muted. If a participant has a question, simply raise your hand using the Microsoft Teams platform. During the question and answer session, please restrict questions to the speaker relevant to the topic under discussion and only pose such question when called upon. To the official welcome of Advocate Georgiades, I now hand you over to Advocate Bart Ford. Advocate Ford.
Thank you so much, AJ, and thank you so much, Chris. Chris, I think AJ got the pronunciation of your surname a little bit incorrectly. I've always pronounced it as Georgiades, but I'm always subject to correction. It is an absolute honor for me to introduce Chris to you. Chris and I were counseled together when I was still at the Bridge Group, and we were neighbors. So every morning when I arrived, I would greet loudly and Chris would return the favor. During those interactions, I've always enjoyed our discussions. I have always found Chris to be extremely approachable, very affable, and extremely amiable. This does not only come through in his manner as a gentleman, but also in his knowledge of law, in particular commercial and admin law. So whenever I was briefed with a commercial brief, in respect of which I needed a second opinion or test something or test my understanding of a legal concept, Chris was always there and always available and always willing to help. And when I asked him whether he'd be able to present this session for us, he kindly agreed. By way of background, Chris joined the Johannesburg Society of Advocates in 1997. He took silk in 2018. Makes this his 24th year in practice, and his areas of speciality includes admin law, commercial arbitrations, banking, commercial law, insolvency, landlord and tenant law, municipal law, and procurement. So we're looking forward to having a insightful session with you, Chris, and I'm handing over to you.
Thank you, Bart, for those very kind words, and I owe you a debt of gratitude for pronouncing my surname correctly. You'll see the shelves behind me are empty, and that's because I'm moving. I'm in the process of moving, but it was indeed an honor that Bart asked me to present to you this talk on Section 417 of the Companies Act. Now, when we speak about Section 417, we're speaking about the old Companies Act 1973 and the chapters that were retained by the new Companies Act, the Companies Act, which is not new anymore, but 2008. Now, the best place to start is perhaps to read Section 417, subsection 1, and that will be a good introduction to the presentation. I'll then outline the purpose, or the nature rather, and the purpose of Section 417, and then give you some more insight as to when such an inquiry will be granted by the court or the master of the High Court. So without further ado, let me read to you the subsection. In any winding up of a company unable to pay its debts, the master or the court may at any time after a winding up order has been made, summon before him or it any director or officer of the company or person known or suspected to have in his possession any property of the company or believed to be indebted to the company, or any person whom the master or the court deems capable of giving information concerning the trade, dealings, affairs, or property of the company. So just to summarize, what I'm going to refer to before I summarize is the sections in law, the paragraphs in law, so that's the law of South Africa. I don't know if you can see this, but I'll give you the text. It's volume 4, part 3, paragraphs 142 to 151. And then the commentary in Henoksburg on the Companies Act, Meskin, volume 1. Those are the sources from which I have prepared this talk. So without any further ado, to summarize the section, in any winding up of a company unable to pay its debts, that's the first part of the section that we need to analyze. That is the meaning of the winding up of a company unable to pay its debts. That, you will know, is a compulsory liquidation and not a voluntary liquidation. A voluntary liquidation is one where the company voluntarily winds itself up. So this section won't apply unless there's a compulsory or a winding up of a company unable to pay its debts. So that's the first feature of section 417. The second feature is the court or the master may at any time after the winding up order has been made, so after the liquidation has already been granted, summon before it or him or her any director. So this now is the category of persons that can be summoned: a director or officer of the company or person known or suspected to have in his or her possession any property of the company or believed to be indebted to the company. Or thirdly, any person whom the court or the master deems capable of giving information concerning the trade, dealings, affairs, or property of the company. So we're dealing here with, firstly, the officers of the director or officers of the company. The officers of the company and the directors can be summoned. That we know, and that is clear. But who else can be summoned? Persons with a legal relationship with a company, such as employees, agents, or even the company's auditors may also be summoned to appear before the master or the court. It's also important to state at the very outset that these proceedings, these 417 proceedings, tend to be conducted in front of a commissioner, and a commissioner who is appointed in terms of section 418 of the Companies Act. The commissioner tends to be an attorney, it can be a magistrate, it can be a retired judge, or it can be an advocate of the High Court. Now, the other distinguishing feature is that only a natural person can be summoned. So you can't summon a body corporate or another company to appear. Now, the nature of the examination. The examination is an extraordinary process. It's a process that arises sui generis, and at the instance of the liquidator, to enable the liquidator to get the requisite, to obtain the requisite information. Now, the examination itself is in the nature of a discovery, so it's not an adversarial litigation process as one would envisage in court. It is rather an inquisitorial inquiry, and that it's mainly at the instance of the liquidator, who will be seeking what I've already outlined, the property of the company or any information concerning the trade, dealings, affairs, or property of the company. So it seems that that the holding of the inquiry cannot be characterized as an administrative action. So it's not subject to Section 33 of the Constitution and to the Promotion of Administrative Justice Act, or PAJA. However, that doesn't mean that a procedure in terms of Section 417 and 418 is not protected by constitutional principles or the principles of natural justice. So what you must remember throughout the proceedings, throughout the Section 417 or 418 proceedings, is that the court is the overarching vanguard of those proceedings. So if there's any abuse, the court will intervene. If there's any violation of the invitee, in other words, the person who's been invited to the 417 inquiry, then the court will intervene, and the court will ensure that no person is denied their rights. Now, the next feature of this section is what is set out in section 417(2)b, is that and I'll read that to you as well and break it down. Any such person may be required to answer any question put to him or her at the examination, notwithstanding that the answer might tend to incriminate him or her, and shall, if he or she does so refuse on that ground, be obliged to so answer at the instance of the master or the court, provided that the master or the court may only oblige the person in question to do so, to so answer after the master or the court has consulted with the director of public prosecutions who has jurisdiction. Then C, an incriminating answer or information directly obtained or incriminating evidence directly derived from an examination in terms of this section shall not be admissible as evidence in criminal proceedings in a court of law against the person concerned or the body corporate of which he or she is or was an officer, except in criminal proceedings where that person concerned is charged with an offence relating to, and then there's 4 offences where it can be used against them. It's the administering or taking of an oath, or the administering or making of an affirmation. So when an offence is related to that, or an offence is related to the giving of false evidence, or the making of a false statement, or the failure to answer lawful questions fully or satisfactorily. So what in essence it means is that any proceedings before in terms of section 417 and 418 are protected, protect the invitee or the person giving evidence, in that the evidence that that person gives cannot be used against them. So they must answer questions, even though the questions are incriminating in the criminal sense, but whatever answers they give will not be used in any criminal proceedings save those that are listed in the section. That is the administrating or taking of an oath, or administering or making of an affirmation, the giving of false evidence, 2, 3, the making of a false statement, and 4, a failure to answer lawful questions fully or satisfactorily. So that's one of the features of section 417. Prior to the case of Ferreira versus Levine, and I'll give you that citation in a moment, the position was that the evidence could be used against you in criminal proceedings. I'm just looking for the citation. I'll come back to that and give you the citation at the end, but it's Ferreira versus Levine. I'll come back to you. I'll come back and give you that citation in a moment. So the next thing that I want to discuss is the purpose of the section, and it's not. I can't put it any better than what is set out in the case of Rolls Razor Limited, a decision that's reported in the All England Law Reports, 1969, 3 All England Law Reports at page 1390. And there, the learned Judge Meggery, made the following, said the following. It's at page 1396 onto page 1397. 1396 against the letter H and ending at 1397 against the letter B. The process under section 268, section 268 is the equivalent of 417 in England, is needed because of the difficulty in which the liquidator is in insolvent company is necessarily placed. He usually comes as a stranger to the affairs of the company, which has sunk into its financial doom. In that process, it may well be that some of those concerned in the management of the company and others as well have been guilty of some misconduct or impropriety, which is of relevance to the liquidation. Even those who are fully innocent of any wrongdoing may have motives for concealing what was done. In any case, there are almost certain to be many transactions which are difficult to discover or to understand merely from the books and papers of the company. Accordingly, the legislator has provided this extraordinary process so as to enable the requisite information to be obtained. The examinees are not in any ordinary sense witnesses, and the ordinary standards of procedure do not apply. There is here an extraordinary and secret mode of obtaining information necessary for the proper conduct of the winding up. The process, borrowed from the law of bankruptcy, can only be described as being sui generis. In such a process, it seems to me that the court must give great weight to the views of the liquidator. With his detailed knowledge of the problems that exist in relation to the affairs of the company and the information that is required. At the same time, the court must be astute to prevent any oppressive, vexatious, or unfair use of this extraordinary process, especially as the liquidator's report is kept hidden from the examinees or the invitees in our instance. So I can't put it any better than the remarks in the case of Rolls Razor, and I'll give that citation to you again at the end if you so require. So the whole purpose of Section 417 is to enable the liquidator to gather information, and to gather information that will assist him in his duties in winding up the company. And it's an expeditious process that is set out in Section 417. But what happens is that it must still protect the invitees from any oppressive or prejudicial or vexatious behavior on the part of the liquidator. And I'll come to that in a minute. But it's important to know that when a liquidator comes into the company, he's a stranger to the affairs of the company. He's got access to the documents, and perhaps not all of the documents, but he's got access to the documents and the papers. And from that, he must now gather what claims the company has against debtors, what claims it may have that he wants to enforce by way of litigation, and what property the company had. So what we call that is the interrogation under Section 417 is to reconstitute the state of knowledge of the company. Not infrequently, the only persons who have knowledge of the workings of the company prior to its liquidation are the directors and officers of the company, and the very persons who are responsible for the mismanagement or the depredation of the company. They sometimes will be reluctant to assist the liquidator voluntarily, and therefore Section 417 was enacted in order that these persons can be compelled to come and be interrogated. So to put the liquidator in the position where he gets sufficient information, he or her gets sufficient information to reconstitute the state of knowledge that the company should possess. Now, it has been said that that there's a public interest in doing so. So one can imagine the Steinhoff situation if Steinhoff were to be liquidated, that there's a public interest in knowing what went wrong with Steinhoff, how it was liquidated, and all the wrongdoings that were carried on by its directors and its officers. But the court will order an inquiry, but it will on application. So you go to court, or you approach the master with an application that so-and-so, a director, officer of the company, an auditor, or an attorney, be summoned to answer questions relating to the affairs of the company, the property of the company, and the trade, what's enacted in Section 7. In other words, the trade dealings, a person who has knowledge about the trade dealings, affairs, or property of the company. So what the court then has is a discretion, and the courts normally exercise control over the inquiry. So what will happen is the court will always exercise control over the inquiry by being the guardian of the over the process. So an application for a private examination won't be granted if it would be oppressive, vexatious, or unfair. And the court, secondly, will intervene to prevent the oppressive or unfair conduct of proceedings in the inquiry itself. So the court won't allow an application that is vexatious or prejudicial to the person being summoned, and thirdly, won't allow the proceedings to be conducted in any way that's unfair, oppressive, or prejudicial to that person. Now, there's also a private character to the application, and that's set out in subsection 7. So it says any examination or inquiry under this section or section 418 and any application therefore shall be private and confidential unless the master of the court either generally or in respect of any particular person directs otherwise. So one can see that the object of the procedure is to keep it secret from the proposed person that's being invited, and is the subject matter of the examination. Because if this information is disclosed to him or her, it might enable him or her to defeat the process of the examination itself. So that goes without saying. But at the inquiry, that person is entitled to be represented at his or her attendance by an attorney or counsel, who may object to any questions put to the examinee, and he shall have the full protection of the court or the master at the time of the examination, or of the court where a commissioner is appointed to conduct the examination, who will either regulate the examination itself or intervene to ensure that the examinee suffers no injustice. So the commissioner will play the role of the court and oversee that there's no unfairness to the invitee or the examinee. Now, the next question is who may apply for examination in terms of this section of the Companies Act? And the obvious one would be the liquidator himself. And the court has a discretion which it will exercise on information brought to him by any interested person. So it's not limited to a liquidator. It can be a creditor or a member of the company who's given notice to the liquidator to bring these proceedings. Any person who applies for an examination or inquiry in terms of section 417 or 418 is liable for the payment of the costs and expenses incidental thereto. Now, you may ask why that is the case. It's the case because it should operate as that provision as to cost will operate as a deterrent to anyone who wants to harass or abuse the person, any person, or abuse the process, the inquisitorial process, for an ulterior purpose. So it serves as a deterrent. Now, the court will exercise its discretion, as I've said to you, when it's satisfied that it's just and beneficial for the purpose of the winding up. So that's the test. It's got to be just and expeditious for the purpose of the winding up, and it must be the appropriate standard that is not one that is prima facie onus, but the appropriate standard is that a proof of the reasonable requirement for the information. So the information must be reasonably required by the liquidator in exercising his or her duties. Remember, this is inquisitorial in nature, so it's not adversarial. Even though the person who's invited can be represented by an attorney or counsel, it has far-reaching consequences, and the court must be satisfied on the application that the inquisitorial powers will not be used in a way that's unjustifiably oppressive or vexatious. Now, what does the court do in exercising its discretion? It balances. So many other matters in your careers, you'll know that the court balances certain factors in arriving at its or in exercising its discretion. This is no different. What is balanced here is the requirements of the liquidator to obtain the information that he or she requires against the possible oppression to that person from which the information is sought. So it's again a balancing of the two interests. And it's also important to remember that the liquidator, when it comes to court, will have the sympathy, when it comes to the master, in order to institute an inquiry in terms of section 417, will have the sympathy of the court or the sympathy of the master, and in that balance. But it's important to know also that it's not there for the asking, just merely for the asking. The liquidator will have to show the court and exercise, so the court can exercise its discretion, that it's just and beneficial for the purpose of winding up. Now, one can imagine a situation where the liquidator could have possible litigation against the third person, against the director, an officer, an employee, or the auditors of the company. The liquidator will invoke Section 417 so that he can be weaponized in a way to bring civil proceedings, or if civil proceedings are already instituted, the liquidator could want to use the inquisitorial proceedings to gain discovery in the litigation that is going on between the third person and the company in liquidation. So the liquidator must be put in a position where he can exercise the rights of the company in liquidation in respect of that litigation. But the courts will also put a brake on it, because he's not entitled, or he or she is not entitled to something more, or to pre-trial procedure prior to or in addition to what's going on in court. So the court will refuse an order for examination if the purpose of the liquidator is to achieve an advantage beyond that which is available to an ordinary litigant in litigation, which he or she has already commenced, or he or she has already decided to commence. Now, there's a quote in Lawsa by Gleeson, Chief Justice Gleeson in Australia, Australian case of Hong Kong Bank of Australia versus Murphy, where, quote, there's no strict dichotomy between an advantage to be gained by an applicant for an examination order, such as a liquidator, in the capacity of a litigant, and the benefit that might flow to creditors or contributories or members of the public from the conduct of the examination. However, the court will always consider the potential prejudice to the prospective examinee in regard to pending civil actions and criminal prosecutions. And of course, the liquidator, if he requires information that's fundamental to the company's cause of action, the court will allow the inquiry and after the balancing process. And conversely, if the liquidator is seeking merely to dot the I's and cross the T's of a fairly clear claim by examining the proposed defendant to discover his or her defense, the balance would come down against making of the order. So that would be oppressive or prejudicial, and such person would be entitled to tell the court that, or rather the court will be the vanguard and say that you're not entitled to discover the defense once you've already established your cause of action. And the court will also take into account the hardship on a witness. An order for oral examination is more likely to be oppressive than the order for production of documents, and therefore calls for a more careful approach. So if the court or the master is satisfied that the liquidator can use alternative sources other than an interrogation or an inquiry, then the court will not allow such an inquiry to take place. And or it can be when the liquidator can readily obtain all such information from sources without incurring trouble or expenses appreciably greater than would be incurred in the desired examination. And then thirdly, that he or she has not chosen to avail himself or herself of such alternative sources. So what you should know out of that is that there's a balancing act and the court will exercise its discretion. I see somebody's got a question. I don't know if it's an appropriate time to take a question. Mohammed, can we possibly take that question at the end?
Let's question and answer to the end.
Okay.
Continue.
All right. I just saw that somebody's hand was up. I wasn't sure. Now, there can also be opposition to the order. Ordinarily, the application won't be served on. It's an ex parte application, so it won't be served upon the examinee. And however, if the prospective examinee establishes that such an application has been brought against him or her, if he or she happens to learn of it, or that an order has already been made, he or she has locus standi to oppose the application or to move to have the order set aside. So the grounds upon which he can do so is the lack of jurisdiction, the oppression or hardship, or possible unusual, special or exceptional circumstances which it may seem appropriate to entertain, as for example, where there are good reasons for having the inquiry at a meeting of the creditors. So in other words, if the inquiry or if the information can be obtained at a meeting of the creditors, then it's not necessary to invoke section 417. He's got to make out a strong case before the court to deny the liquidator his rights in terms of section 417. So although the application for the examination is private and confidential, both the court and the master may otherwise direct, either generally or in respect of a particular person. In the exercise of this discretion, the court or master may, in a suitable case, relax the rigidity of the order, each case depending on its merits. Inspection by the proposed examinee would prima facie be allowed where the court or the master is of the opinion that he or she will or may be unable to fairly and properly dispose of the application, or the proposed examinee's application to have the order set aside is part of the evidences. In other words, it will be a good reason for disclosure if it appears that without access to the application, the proposed examinee will or may be unfairly prejudiced in the conduct of his or her opposition to the order or his or her application to have it set aside. So ordinarily, the examinee won't be entitled, even though he gets wind of the ex parte application, won't be entitled to the papers or the further and better particulars. Although that now is open to some doubt with the enactment of PIA, the Promotion of Access to Information Act, and there's a good discussion in Henoksburg on that. And I won't go into it, but it's part of the private and commentary under the subsection 7. So going back to the section now, I wanted to refer to subsection 3 as well and read that to you. The master or the court may require such person to produce any books or papers in his custody or under his control relating to the company, but without prejudice to any lien. So that's important. It's subject to a lien. With regard to any books or papers, and the court shall have the power to determine all questions relating to any such lien. Subsection 4, if any person who has been duly summoned under subsection 1 and to whom a reasonable sum for his expenses has been tendered, fails to attend before the master or the court at the time appointed by the summons, without lawful excuse made known to the master or the court at the time of the sitting and accepted by the master or the master or the court may cause him to be apprehended and brought before him or it for examination. So that speaks for itself. You can't ignore the summons unless you have a reasonable excuse, and once the reasonable sum is tendered for your expenses, you have to attend the inquiry. So regarding the examination of witnesses, it's very wide and anyone could be interrogated, provided it's relevant, of course. He or she may be required to answer questions put to him, notwithstanding that the answers have been incriminating. I've already said that to you, and that can be represented by an attorney or counsel. And remember all along that the court is the vanguard and will intervene where there's oppressive and vexatious questions or motives behind the inquiry. The court has the power to intervene, and in order to prevent injustice, it will come to the assistance of the examinee to ensure that the provisions of the section compelling the testimony are not used in an oppressive and vexatious manner or an improper purpose or one which constitutes an abuse of power. So for example, there's another example that the court may refuse to permit a particular question to somebody if it's going to prejudice their right to a fair trial in criminal proceedings, even though that can't be used against them. If the invitee shows that he's being prejudiced, then the court won't allow, or rather the commissioner won't allow the question. Now, I promised you the Ferreira versus Levine citation. It's 1996, Volume 1, SA 984, a decision of the Constitutional Court, at page 111. Yes, so just lastly, to round off the, I see it's 25-2. Just two more points that I want to make is that the court or the master may require any person who is summoned to produce any books or papers in his or her custody or under his or her control relating to the company, however confidential or incriminating they might be. And a court of appeal will not readily interfere with the court's exercise of its discretion as to the production of such documents. So it's only subject to a lien, and I've read that to you already. The failure to attend, we've already covered. If any person who has been summoned and to whom a reasonable sum for his expenses has been paid fails to attend, or fails to attend without lawful excuse, that person may be apprehended. And such person may also be ordered to pay the costs compelling him or her to attend. So what I've done is I've paraphrased from Lawsa, as well as the commentary in Henoksburg, as I said to you I would do. So that's in a nutshell, because there's a lot more that one can consider in questions put in, or in instances where the court might grant or refuse. And I'll let you read those in your own time in Lawsa. So I think we can now take questions if that's possible.
Thank you for the exceptionally informative Georgiades. Did I get pronunciation of the surname?
Sorry?
Advocate Georgiades.
Yes. Georgiades.
Georgiades. On a lighter note, I'm sure that in your early years of practice, when you were standing before judges who were not familiar with you, you had to repeatedly spell your surname constantly.
Yes, and pronounce it.
Advocate, just give me 1 second. I'm going to now open the question and answer session for participants to pose their questions directly to you. All right, I have now opened the platform for a brief question and answer session. By way of a reminder, participants who have a question, simply raise your hand using the Microsoft Teams platform. I shall pose the first question. My question emanates from the Roaring and Another versus Malagungu judgment, with particular reference to the Supreme Court of Appeal judgment in this regard, and not the High Court judgment, as that has been set aside. Placed before the Supreme Court of Appeal was the circumstances that might justify a witness under subpoena applying for inquiry proceedings to be set aside, or for the witness to be excused from attending those proceedings. The Supreme Court of Appeal held that the process involved in making such assessment could not in the normal course constitute an abuse. However, in certain circumstances, inquiry proceedings could indeed constitute an abuse. The judgment essentially empowered courts to have the power, and indeed an obligation, to restrain the use of power of an inquiry where it would constitute an abuse.
Yes.
I have unfortunately not come across any legislation which legislates exactly what constitutes an abuse. My submission in this regard is that the fundamental issue in determining where an abuse has occurred was whether the inquiry was being used for the purpose not contemplated by the Act. Alternatively put, the use of the process or abuse of the process will essentially depend on the purpose rather than result. Counsel, would you agree with my submission pertaining to how courts would determine what would constitute an abuse? And if so, what is your comments in that regard?
I do agree with your submission. My comments would be that it would constitute an abuse in circumstances where there's a trial that is contemplated or commenced, and the liquidator goes on a fishing expedition and attempts to gain an advantage that he would not ordinarily be entitled to as a litigant. That would be an abuse of the process. It could also be oppressive, where a person, or prejudicial, where a person is undergoing criminal charges, and his or her trial is proceeding, and that person won't be given a fair trial should the interrogation occur before the trial is concluded. And I've read to you the circumstances from there. And also, I've forgotten to say, that just reminded me that obviously information that is privileged cannot or won't be divulged in these circumstances in an interrogation. But I do agree with your sentiments. It's difficult to envisage exactly what's vexatious and examples of what would be vexatious and undue hardship and prejudice. But I think on a case-by-case basis, the courts will exercise their discretion in a responsible way and protect persons from such abuse, or any abuse. For example, if the proceedings are calculated to harass a particular officer of the court or a director or any other person.
Thank you so much, Counsel. There's a question.
I don't know if that answers the question.
Indeed. Thank you so much. There's a question from Patel, Advocate Patel. You can simply unmute your mic and your camera.
Good evening, Chris. How are you? It's a pleasure to see you after, it's been like just, I think, over a year since the last time we had a chat.
Yes.
First, I need to say thank you for availing yourself and giving us this lovely webinar. I think it was informative for all the participants, and I need to thank you for making your time available. Chris, I'm sorry for raising my hand earlier. I just had a question, and then later on, I think towards the end, you actually addressed it somewhat. It's with regards to the hostile witness, or the witness that gets summoned to such inquiry and fails to come forth. For example, we know those guys that are hiding out in Dubai, and they have many coal mines and the like sitting here in this country, and there's various commissions trying to get them here. So with regards to the costs, I know if you have a witness that doesn't have a legitimate reason for not coming through, then the costs will obviously be borne by themselves once we actually get them, but that's after the subpoena and the like. But say, for example, I'm one of those individuals, and if I had to come through, I mean, the state would have to pay, or whoever needs to pay would need to pay for my protection, would need to pay for my accommodation, would need to pay for me to attend on the particular day. So will the state still have to incur the cost, or would I have to fork that out for myself during the duration of the commission? And if whatever I state during the commission is fraudulent, or obviously a misappropriation of funds or corruption of the like, and it would lead to criminal sanction, for that duration of between the commission or this inquiry in the civil court to the actual proceeding going to be continuing in the commercial court, throughout the duration, who's going to be looking after it? Who's going to be bearing that cost for the duration? Thank you.
Mohammed, the Act says that the reasonable costs, the liquidator will tender the reasonable costs of the attendance of that person. So if the person is overseas and it's required that he come, that may be the case. If he's reluctant to come and he's somehow extradited, then obviously the cost will be borne by him. I don't see anyone being compelled, or, if they're extradited, it'll be for criminal charges and the state will bear the costs. I don't think the powers of subpoena in Section 417 extend beyond our borders. So I think that, I think to answer your other question relating to if such person doesn't or gives false evidence, then that can certainly be used in criminal proceedings relating to any of the offences, like giving of false evidence in Section 417 2C sub 3.
Thank you so much for your answer, Chris. Really appreciate it.
All right. I hope I answered.
Thank you, Counsel. There's a question from Advocate Ford. Advocate Ford?
Yes.
Chris, I've got two questions. I'm going to start with the first one, and the second one is more an example or a situation requiring an answer. The first is, if a witness who is subpoenaed has the right or protection against self-incrimination for purposes of criminal proceedings, does that protection apply insofar as the institution of civil proceedings against individuals such as directors, and could they, under those proceedings, be sued in their personal capacities? That's the first question. The second question requires a bit of background, and the situation is briefly as follows. The plaintiff got a money judgment against a company called, for the sake of the exercise, called Coolgate, spelled COOLGATE. In trying to give effect to the money judgment, sending the share of returns with an Ulabuna return, that company has since stopped trading. But there's a new company that's been established called Coolgates with an S at the end. And it's exactly the same directors who appear as directors in company Coolgate and company Coolgates. The Coolgate has now stopped trading. Under those circumstances, whilst Section 417 deals particularly with liquidation proceedings, is there not an instance where one could also have an inquiry to investigate the conduct of those directors in that first company?
Yeah, the answer to your first question, Bart, is that you certainly can use the answers or the interrogation in civil proceedings, in subsequent civil proceedings, and sometimes that's the purpose of the liquidator bringing the Section 417 inquiry, is to establish these facts in order, or the cause of action that it requires, or to complete the cause of action once it's to get evidence to complete or to prove the cause of action in subsequent proceedings, in civil proceedings. That certainly can be done. So that's the answer to your first question. There's no protection as there is in criminal proceedings. Then the second part is, yes, an inquiry can be held in respect of the first company, and those directors can be summoned to answer questions as to why the company is no longer trading as Coolgate and now it's trading as Coolgates, if I got you correctly. There would have to be evidence of a disposition of some sort, because if the business was sold, that certainly that transaction can be set aside by the master and set aside by the court, because it's clearly it appears to be a sham in your set of facts. So I don't know if that answers your question.
Thank you so much, Judge. There's a question from Kessler. Kessler, you can simply unmute your mic and your camera.
Hello, my name is Kessler from the Cape Bar. I'm afraid I didn't catch all of the talk, unfortunately, but I have two short, quick questions. The first is, one of the jurisdictional facts for 417 is that a company must be unable to pay its debts. And there seems to be some confusion in the law as to whether that is unable to pay its debts in the ordinary course or unable to pay its debts in the course of being wound up, so in the process of liquidation. I was wondering if you had thoughts on that question. And the second question is, it's not uncommon to see liquidators bringing 417 applications, but in those applications seeking an extension of their powers under 3865. And it seems to me that there might be a problem with doing that, because obviously a 417 application itself is a secret application, and liquidators seek all of the extended powers under I can't recall which section it is, 3864, 3863, and that seems to usurp the democratic rights of the creditors without them being able to contest the application or to intervene, because the application is a secret application. And I was wondering if you had two thoughts about that in relation to the question of abuse. I raise that because Bernstein says that the abuse must be scrutinized at two levels. The one is in the bringing of the application itself, and the other is in the inquiry. And it seems to me that there might be a question of abuse in the bringing of the application on those two levels. Thank you.
Sorry, I'm just going to ask you to repeat your second question. I want to answer the first question first. So unable to pay its debts is a compulsory liquidation. If it's a voluntary liquidation and it appears subsequent to the commencement of the voluntary liquidation that a member or a creditor successfully applies to the court for a winding up order, then of course Section 417 will apply and the jurisdictional fact will be met. I don't know if that answers your question.
It does. There are some authorities that, I suppose, put the question a different way, or sorry, places answer differently. I mean, in Khalil versus Decatex, for example, and there's another judgment by Justice Wunsch that I can't recall the name of the case now, but what the courts there say is that when you bring the 417 application, you must demonstrate in that application that we're not dealing with insolvency in the ordinary course as a factual insolvency. You're dealing with commercial insolvency. So the company is unable to pay its debts in the process of being wound up. That's what you have to demonstrate when you bring the application. I don't know.
So in other words, you couldn't bring it under the deeming provision. You'd have to factually show that it's unable to pay its debts.
Yes, and one of the justifications for that is, of course, it's an extraordinary thing, a 417. Ordinarily, you grant ordinarily you go for a 415, a public inquiry instead of a private inquiry. And because a private inquiry has the potential to be more oppressive, you have to demonstrate strictly that all the jurisdictional requirements are met. And Justice Corbett seems to interpret in Khalil versus Decatex that it's commercial insolvency, which 417 is geared towards, not just factual insolvency.
Yes, okay, I've learned something from you. I wasn't quite aware of the distinction. I always thought that unable to pay its debts is that a compulsory winding up, Section 417 would apply. Yeah. Sorry, just repeat your second question.
So the second question is that very often, or at least sometimes, when 417 applications are brought by liquidators, they do so together with relief seeking an extension of their powers under 6.5 of the Insolvency Act. Of the Companies Act. And the 3865 thing, I've always had some trouble with it because that gives the court the power to extend a specific power of a liquidator where it is necessary for a particular thing at that moment. Ordinarily, an extension of powers is granted by the creditors at the second meeting instead of the court.
Yes.
But it's not uncommon, especially in the Western Cape Division, it seems, that a 3865 extension of liquidation of powers is brought together with the 417. And it seems to me that that might be abusive because it's a secret application. The creditors don't know that the liquidators are seeking this extension of powers. Sometimes the liquidators seek that extension even when they're only provisional liquidators appointed merely days before. And I was just wondering if you had thoughts about that being an abuse.
Well, yeah.
I've seen that before.
I haven't seen it before, but I would agree with you. Section 417, if it's an extension of the liquidator's powers, it would certainly be abusive in circumstances where the creditors are unaware of the secret or the privacy one. And Section 415 would be a more preferable. But I think that again the courts will guard against any such abuse. If they deem it to be abusive or vexatious in the circumstances of the case.
One would hope.
Yeah, one would hope. Hope springs eternal. Thanks.
Advocate Chris, there are a number of other questions from the participants. However, time does not permit for such, and regrettably, I have closed the question and answer session. Advocate Bart shall be conducting the closing. Over to you, Advocate Bart.
Just again, thank you so much for your time. It is invaluable, your inputs and your insights, and I'm sure the participants who may have wanted to ask a question, that the door was not permanently shut to them. I'm sure if they could drop you an email and say, I've had this burning question, unfortunately time didn't permit, that you would be able to accommodate those questions.
Yes, definitely.
Yeah. Again, from us, Chris, thank you so much for your time. Everything of the very best with your move. And I hope to see you soon for perhaps some coffee and watch tennis.
Thanks, Bart. Yeah, we always discuss tennis, didn't we?
Yeah.
All right.
So, thank you so much again. And thank you to the participants for your attendance.
Thanks.
By way of final conclusion, on behalf of the South African Bar Association, we sincerely thank Advocate Chris for his inspiring address, Advocate Bart for his reflective introduction and conclusion, and express our sincerest appreciation to all those that have participated virtually and shall be watching this session at their leisure. These sessions are recorded, and the recordings can be found upon the South African Bar Association website, that being www.rsabar.net. I thank you.